attacks on the Nigerian judiciary by some persons claiming to be aggrieved over some decisions of courts in one way or the other. As a body for reform and advocacy, we have painstakingly looked into the reasons being advanced people attacks, and we have come to the conclusion that the attacks are needless, baseless, and unwarranted. We are therefore urging you to join us in a vital mission of protecting the Nigerian judiciary from the unwarranted criticisms. As Nigerians, especially lawyers and ministers in the Temple of Justice, we have a unique responsibility to defend the judiciary, which is the cornerstone of our democracy. Today, we must address this pressing concern that threatens the very fabric of our democracy. Quote, the incessant attacks on Nigeria's judiciary. These attacks not only undermine the rule of law, but also erode public trust in our institutions. This harmful practice undermines the very foundation. It is imperative that we recognize the judiciary's role as the guardian of justice and the protector of our constitutional rights. We must take collective action to safeguard its independence and integrity. If we fail to address these attacks, we risk plunging our nation into chaos, anarchy, and lawlessness. The judiciary's inability to function effectively will embolden perpetrators of violence and undermine our ability to hold them accountable. It is common knowledge that our judiciary system is built on the principle of fairness and impartiality. Judges render verdicts based on evidence and legal precedents before them. Disagreement with judgment delivered by judges is natural, but violence, blackmail, and intimidation of judges are unacceptable. In every dispute, one party must win and another must lose. This fundamental principle ensures justice is served. In addition, it is common knowledge that once decisions of court do not favor a certain interest, they needlessly resort to attacks on the judiciary. Conversely, once it favors them, the judiciary is right and be praised to high heavens as the hope of the common man. That is typical of what these groups of persons tarnishing the image of the judiciary are doing. Let the point be made here that judges do not assign cases to themselves. It is the administrative function of the chief judge, and that is why cases similar in nature are usually assigned to a particular judge or judges to avoid conflicting decisions. For instance, most of the cases at the Federal High Court here in respect of Edo and Rivers States were assigned to two judges despite being vacation matters. Emotions can run high when we lose our cases in court, but let us keep calm, consult our lawyers to understand the judgment and exercise our constitutional right to appeal to a higher court. By appealing an unfavorable judgment, upholds the rule of law, ensures justice is served, and strengthens our democracy. We must be patient and trust the appellate process. Our appellate courts review decisions of the trial court and ensure that errors are corrected, laws clarified, and at the end, justice is served. But attacking judges undermines judicial independence, threatens national security, deters judges from making fearless decisions, and erodes public trust in the justice system. Let us at this juncture plead with lawyers, my colleagues, to understand their roles as ministers in the sacred temple of justice. Lawyers are the guardians of justice, serving as ministers in the temple of justice. Their role is not only to advocate for their client, but also to uphold the integrity of the judicial system. As ministers of justice, lawyers must balance their duty to their clients with their duty to court, ensuring that justice is served. In this sacred temple, lawyers are the essential intermediaries between the laypersons and the judiciary. Their expertise and knowledge of the law enable them to navigate the complex legal landscape, providing guidance and representation to those seeking justice. However, being a minister of justice comes with immense responsibility. Lawyers must conduct themselves with integrity, honesty, and respect for the rule, and respect for the law, and the judiciary. Regrettably, these incessant attacks on the Nigerian judiciary are being championed by so many lawyers. These lawyers descend heavily on judges and attack their character after losing cases in court. This professional conduct must stop. The attacks on the judiciary by Professor Chidi Odekalo and Honorable Ikenga Ugochidin are uncalled for. They should desist from it, as they are not only unprofessional but also criminal. Decency and decorum must not be thrown to the wind under the guise of fighting for clients. While we consider that they have fundamental right to freedom of speech, it is unethical for any lawyer to engage in dragging the judiciary into the murky water. We therefore, with the greatest respect, call on the Nigerian Bar Association to raise the occasion and sanction erring lawyers who attack judges to massage their ego after losing cases in court. It is the duty of the Nigerian Bar Association to shield the bench from unfounded criticisms, as judges cannot respond to criticisms or defend themselves. They must remain impartial and silent, even in the face of unfair attacks, though this silence is not weakness but strength. The Nigerian Bar Association must ensure its members uphold judicial integrity, promote public interest in the justice system, and educate clients and the public on the judicial process. If the Nigerian Bar Association fails to protect the bench, these incessant attacks on judges by lawyers will damage the reputation of the legal profession, cause the legal profession to lose credibility, undermine public confidence in the judicial system, and justice will be compromised. Every lawyer must demonstrate respect for the judiciary, integrity in the legal practice, and commitment to justice. By doing so, they strengthen the legal profession, foster positive reputation, uphold the rule of law, and ensure a fair justice system for all. Lawyers must honor their oath and uphold the integrity of the judiciary. The Nigerian Bar Association must stand united to support judges in their quest for justice and promote a culture of respect for the judiciary. We, therefore, call on the Legal Practitioner Disciplinary Committee to take actions against lawyers who indulge in this harmful practice of attacking judges in Nigeria. Finally, we encourage lawyers and litigants to follow established channels to ventilate their grievances. Apart from exercising their constitutional right of appeal, they can also petition the Nigerian Judicial Council against any judge on account of judicial misconduct, allegation of bias, corruption, etc. It is the responsibility of the National Judicial Council to investigate and ascertain the veracity or otherwise of the allegations against judicial officers and not the social media. We must work together to build a justice system that inspires confidence and trust and stop these incessant attacks on our judges. We must unite against these incessant attacks on the Nigerian judiciary and build a better Nigeria for ourselves and future generations. We must unite in our quest for justice and peace. We must work together to build a Nigeria where the judiciary can function without fear or favor. We owe it to ourselves, our children, and future generations to act now. The time to stop these incessant attacks on our judiciary is now. Thank you all. And my name remains Carlo Ago, Head, Legal Services, Center for Reform and Public Advocacy. Thank you all.
Now it's time for question and answer. If you have any questions, any raise your hands. Questions? Okay, can you kindly pass the mic to the one right?
Good afternoon, ladies and gentlemen. Comrade Harry Negebe is my name. In one of his interviews, Professor Chidi Odekalu, on one of the orders of FCT High Court on Abuja protesters, he asserted that persons unknown cannot be sued. And can persons unknown be sued in law? So we want that to be answered. Because as a professor of law, when he made that statement, some of us are confused. So we need to be guided on that. Hence my question. Thank you.
Thank you very much. My name is Emmanuel Bagudu from New Central Television. So if you look at the nature of both Professor Odinkalo and Ugochinyere, these are, apart from being lawyers, they are activists. Now, an activist, whether I like it or not, makes Odinkalo do more of his job as more of an activist than a lawyer. So how do we differentiate this job from an activist to a lawyer? It's like trying to say you should keep quiet, and then maybe transition the job of an activist and just concentrate on being a lawyer. So how do we, how does he differentiate this issue, him and Ugochinyere? Thank you.
Thank you very much. Let me start by answering the first question. Can persons unknown be sued in law? By our rules of court, it is clear that persons unknown can be sued. And there are several decisions of the appellate court on that. So persons unknown in law can be sued. Professor Chidi Odinkalo should know as a professor of law. Thank you. Then on the second question, how do we differentiate the issue of activism and being a lawyer? What we are talking about here is attacks on the judges, on the Nigerian judiciary. And the attacks are being done by human beings, not by spirits. So as a human being, you can be an activist and at the same time being a lawyer. All we are saying is, don't attack the judges. There are established channels where you can ventilate your grievances on matters that you disagree with the decisions of the courts, not jumping to the social media and start to attack the decisions of the court. When the Constitution, which is the grand norm of this country, has laid or has given the person the constitutional right of appeal. Apart from the constitutional right of appeal, the person, if you feel that the judge in question has compromised his status as a judge, there are legal procedure. You can petition the agency that is saddled with the responsibility of disciplining judicial officers and not jumping to the social media to talk on things you know that when you are confronted, you may not substantiate your claim or your allegations against them. I think that settles the second question. Are there other questions?
My name is Kayode Lawal. I write for the Herald newspaper. Now, the general belief is that the courts in Abuja here, they are granting more orders against the issues in Rivers State. How do you respond to that one?
First and foremost, nobody has the statistics of the judgments or rulings of the FCT High Court in respect of matters concerning the Rivers State, concerning Rivers State. Nobody has the statistics. But let it be made clear that the courts are established to hear and determine matters before them. Any matter that is not before a court cannot be heard or determined by the court. If there are many cases from River State, it is the duty of the court to hear and determine the matters one way or the other. Like I said, why we are here is to place it on record that going forward, that our NGO, the Center for Reform and Public Advocacy, will not fold its arms again and allow people jump to the social media to attack on the integrity of our judges when there are laid down procedures, established channels through which they can ventilate their grievances. If a judge of the Federal High Court gives a decision which a litigant frowns at, he has options either to appeal or to petition the agency over a misconduct against a particular judge, not to jump to social media to say what he may not substantiate. That is why we are here.
Comrade Henry is my name. In one of his interviews, Professor Chidi Odikalu, professor of law, when he made that statement, some of us are confused, so we need to be guided on that. Hence my question.
Odikalu and Ugochinyere. These are apart from being lawyers, they are activists. Now, an activist, whether I like it or not, makes Odikalu do more of his job as more of an activist than a lawyer. So how do we differentiate this job from an activist to a lawyer? You're just like trying to say you should keep quiet, and then maybe jettison the job of an activist and just concentrate on being a lawyer. So how do we differentiate? How does he differentiate this issue, him and Ugochinyere? Thank you.
Are there more questions?
So persons unknown in law can be sued. Professor Chidi Odikalu should know as a professor of law. Thank you. Then on the second question, how do we differentiate the issue of activism and being a lawyer? What we're talking about here is attacks on the judges, on the Nigerian judiciary. And the attacks are being done by human beings, not by spirits. So as a human being, you can be an activist and at the same time being a lawyer. All we are saying is, don't attack the judges. There are established channels where you can ventilate your grievances on matters that you disagree with the decisions of the court. Not jump into the social media and start to attack the decisions of the court when the Constitution, which is the grand norm of this country, has laid or has given the person the constitutional right of appeal. Apart from the constitutional right of appeal, the person, if you feel that the judge in question has compromised his status as a judge, there are laid down procedures. You can petition the agency that is saddled with the responsibility of disciplining judicial officers and not jumping to the social media to talk on things you know that when you are confronted, you may not substantiate your claim or your allegation against them. I think that settles the second question. Are there other questions? Statistics of the judgments or rulings of the FCT High Court in respect of matters concerning the River State, concerning River State. Nobody has the statistics. But let it be made clear that the courts are established to hear and determine matters before them. Any matter that is not before a court cannot be heard or determined by the court. If there are many cases from River State, it is the duty of the court to hear and determine the matters one way or the other. Like I said, why we are here is to place it on record that going forward, that our NGO, the Center for Reform and Public Advocacy, will not fold its arms again and allow people jump to the social media to attack on the integrity of our judges when there are laid down procedures, established channels through which they can ventilate their grievances. If a judge of the Federal High Court gives a decision which a litigant frowns at, he has options either to appeal or to petition the agency over a misconduct against a particular judge, not to jump to social media to say what he may not substantiate. That is why we are here.
After the judge had delivered his judgment, to make a comment, after the judge had delivered his judgment, that is what I'm trying to say is, if you are the judge and you have delivered your judgment, like you delivered it, have I no right to go outside and say what is in my mind? Under freedom of expression.
My name is Emmanuel Aikele and I report for Channel Television. Just a quick question. Now, Mr. Gochinyere had said they were going to march to the NJC concerning this issue. As a lawyer, I don't think to do. What is your thoughts on this? Thank you so much.
Whether a litigant has a right to comment on judgments delivered in his case, the answer is yes. But don't attack on the integrity, on the person of the judge. Some people run to social media and say this judge is corrupt. Can you substantiate that? That this judge is compromised? Can you substantiate that? But you can say, I feel that the judge erred in the interpretation. That's all. That's your feeling. But not to attack on the person or on the integrity of the judiciary. I was taught by so many professors in the University of Nigeria and Soka, and so many of them, in their textbooks, they disagreed with judgment of the Supreme Court. They would suggest that this is the way they feel about this judgment. This is my opinion. But never said in their books that the judges were corrupt or they were compromised. I hope that answers your question. Then on the issue of marching, that lawyers will march to NJC, that is not what our rules or the laws tell us or provide. It says you can petition. To petition the NJC and to walk to NJC, they are not the same. They are not. For lawyers to walk to NJC is an unprofessional conduct, which our professional rules frowns at. Thank you.
The court individuals have jurisdiction or they don't have? Or why are they bringing most of their cases to Abuja?
Litigants have the right to pursue their legal issues in court. In filing some of these processes in court, if you file as a litigant, it is not your responsibility to decide, to hear, and determine the issues you brought to court. So wherever you file, the issue is what is the ruling or what is the outcome of the matter you file in court. So if you file wrongly, the adverse party has the right to raise preliminary objections on jurisdiction and even on the locus of the litigant. So wherever you feel as a litigant you want to go and file your process, you are free. But whatever the outcome of the process you file in court, you take. But all we are saying, so as we do not digress why we are here, is that wherever you file your process and the decision is given one way or the other, don't jump to social media to start to attack on the judges that heard your matter.